ahead, slowing down and taking no time. I gotta keep it rolling. Those in the windshield wipers snapping out the tempo, playing perfect rhythm with the song on the radio. I gotta keep it rolling.
Hey, what's up, everybody? Welcome to the Ride Share Rodeo podcast. Today we have a special podcast, and we are streaming on Facebook, Twitter, YouTube, LinkedIn, and Instagram right now. Today's discussion is titled, Why We Sued the Department of Labor. My guests today are Wilson Freeman from Pacific Legal Foundation and Kim Kavin from Fight for Freelancers. And welcome, Wilson and Kim.
Thanks, Steve.
Great to see you again, Steve.
So, thank you everybody for joining us in all the live chats. I'm trying to keep a little bit of, most of it I'll see come through. Just no Instagram people, not avoiding you. They just haven't integrated the chat feature yet. So I can't see anything you're writing, but I'm trying to watch on a little phone here in case you guys have a comment. I will do my best. But we will have people from all over the country listening. So let's just get right into it. Since we have Wilson here, Wilson, can we start off today by going through the lawsuit itself?
Sure, Steve. So, as you mentioned, I'm with the Pacific Legal Foundation. We filed a lawsuit challenging the new Department of Labor rule, which was finalized in early January of this year. The rule establishes the scope for the department's interpretation of who is an employee and who is an independent contractor under the major federal labor law, the Fair Labor Standards Act. We're challenging this interpretation as contrary to the statute and as promulgated arbitrarily and as contrary to the Constitution. So we're hoping to have that rule set aside, and I can talk more about the details of the challenge if you'd like.
Yeah, I would like our audience to know, because we've had a handful of discussions about this. I've been making even the gig app community aware because, and just to hit on this real quick, many are convinced this can't affect them. And I've had to say that, how do you know? We've never been here before. and honestly, we are independent contractors in the eyes of the app. So I don't see how it potentially couldn't hurt us.
I think it definitely affects so-called gig workers. It affects my clients. My clients are 4 freelance writers, including Kim, who's on the call, as one of the plaintiffs in this case. Mm-hmm. So what you and your listeners need to understand about the Fair Labor Standards Act is that it applies to every worker in the country. The Fair Labor Standards Act says that if you're an employee, any employee, your employer needs to pay you minimum wage and overtime and track your hours for the hours worked, among other things. Mm-hmm. So independent contractors, of course, it's just anybody who's working, who's essentially anybody who's not an employee is an independent contractor. You don't have to pay independent contractors minimum wage. You don't have to pay them overtime. So right now, if you're an independent contractor under the Fair Labor Standards Act, there's no need for, if you're, for example, driving for Uber, if you're one of my clients, you're a freelance writer working for a magazine, the magazine doesn't need to track how long you're working. Uber doesn't need to track how long you're working. They don't need to divide your hours up if you're driving for Uber and Lyft, for example. You just need to know that, you're just getting paid, in your case, on like a piece rate or drive rate type thing. But if you were an employee, you would have to get paid, they would have to track your hours because you have to be making a minimum wage, and minimum wage is, generally speaking, calculated on a per hour basis. So this rule is very important because what this rule does is it sets out the scope for determining who's an employee under the act. And as I just mentioned, if you're an employee, you're going to be subject to these sort of very demanding requirements for your employer. So that goes to the question of, well, look, I get a 1099. I call myself an independent contractor. Therefore, what's the big deal? Well, that's not the way the Department of Labor looks at the question. The Department of Labor says, this is, whether you're an employee under the Fair Labor Standards Act has absolutely nothing to do with what you call yourself. It has nothing to do with whether you get a 1099. It has to do with the so-called economic realities of your situation and your bespoke situation, whatever that may be. So that means that for any given worker in any given profession, whether or not they're an employee is a question that that really has to be answered if you want to work with them as an employer or as a client. In the case of an independent contractor, you have to have some sort of certainty about whether or not they're an employee or not, because otherwise you could be stuck not paying them overtime and then getting on the hook with a lawsuit later or a Department of Labor investigation later. You don't want to be in that situation. So this is all background. At the end of 2021, or at the beginning of 2021, at the end of the Trump administration, the administration promulgated a rule setting out the scope for who's an employee and who's an independent contractor under the Fair Labor Standards Act. And that rule set forth what we see as a pretty clear test. And under that rule, if you, as a worker, exercise control over the way that you do your work, if you have control, and if you have an opportunity to make profit, so in the case of a driver, if you have the opportunity, to drive more efficiently, or the way that you drive, or the way that you sort of manage your day to day, if you have those two things, generally speaking, you're going to be an independent contractor. And that gave companies that work with independent contractors a lot of certainty and a lot of comfort, so that they could be comfortable hiring independent contractors and knowing, hey, I don't have to worry about the Department of Labor coming after me later, or about disgruntled workers filing a lawsuit against me later for failed lack of overtime pay. So that was a really important rule. Well, needless to say, when the new administration got in, the first thing they did was try to withdraw that rule. That withdrawal was struck down by a court. A court said, you can't just withdraw this rule for no reason. You have to give a very reasoned explanation as to why you're going to take it out. So that brings us to the present day. The Department of Labor has now put out their so-called reasoned explanation. They've withdrawn this 2021 rule, which gave companies a lot of certainty, and put in this new rule. This new rule is much more open-ended, and we characterize it in our lawsuit as being unconstitutionally vague, and I think that it is. The new rule is a 6 or maybe 7-factor test, which looks at a bunch of different things to determine whether or not a worker is an employee or an independent contractor. But none of those factors, whether it be, again, control is one of the factors, degree of permanency of the working relationship is another factor. So in the case of a rideshare worker, if you're driving for Uber all the time, that's a very permanent relationship. The amount of skill that you have to do your job is one of these factors. The importance of your job to the business of the company you're working with, the so-called integral nature of your job, that's another factor. So they have all these factors. They then have a 7th factor, which is a catch-all. It just says anything we forgot to mention could also be important to this question. The Department of Labor doesn't say how those factors are going to be weighed. They don't tell you what facts are important. They just say, here are some factors which we're going to consider when we determine whether you are an independent contractor or not. But, we're not going to tell you how to weigh them. It's a totality of the circumstances test. It's a bespoke analysis, which for every different worker could be totally different. And that's all you get. That's all we're going to let you know. And then now that's the rule. Or that will be the rule in March when this rule goes into effect. This is really important to independent contractors and to freelance writers like my clients who have been working as independent contractors for a long time. Their customers need to know what the rules are in order to be able to do business. The Department of Labor is saying that, here's a 6 or 7-factor test, and we're not going to tell you how to weigh any of these factors. It gives my clients absolutely no certainty, no way to know what the rules are that apply to their relationship. And it threatens their business because future customers are going to be chilled by this new rule. And so I think this is something that, independent contractors do need to worry about. Many of them are worried about it. Almost all of the comments from independent contractors on the rule opposed it. Yeah. But, the Department of Labor enacted the rule anyway, ostensibly to protect those same independent contractors. So that's where we stand. As I said, we've challenged the rule. I can talk, I can talk endlessly about this, so I apologize if I just keep
No,
going.
no, I mean, like, for one thing, I would like to know is I'm confused about like the legality of passing this rule. I mean, when Julie Sue was putting the acting position in March of last year, she was supposed to have what, 220 days to be confirmed. So that would have been September, right?
Well, we
In
didn't
September,
challenge.
that didn't happen, and here we are in the second 118th Congress, and she's still there. I do not understand.
Well, we didn't bring an appointments clause challenge here. I mean, I think that might be problematic. It's just not the focus of our lawsuit, though. We've chosen to focus instead on the flaws that we see in the rule itself rather than
Sure.
sort of the procedural errors in terms of who's enacting it and whether Julie Sue can appropriately sign that or not. That's just not a focus of our lawsuit. So I haven't developed a detailed opinion on it, but I can
I
see
guess
where
I
you're
just see it as
Sure.
the Biden administration tried to push the PRO Act, and Kim and I have talked about this at length, and they tried to shove it through in pieces because that didn't work, and they tried this, that, the other, and now it's here we are in potentially the last year of his stay, and he just keeps somebody who's still not passed in. This gets passed. I feel like I mean, what do you have to go back over 100 years if the president who's controlling the office in the Congress is held by the same party. You have to go back 100 years to find somebody who can't get confirmed,
I mean,
and so their own party can't confirm her.
it's surprising, but what you need to realize is the Department of Labor here, I think they're operating kind of within a reasonable understanding of what it is they're interpreting the Fair Labor Standards Act, or they say they are. They're not, and that's something they did in the Trump administration. The question is whether they can turn that interpretation on a dime, which is what they've done. They've essentially turned from one understanding of the Fair Labor Standards Act. Again, this is a statute that's been around since 1938. This is not a new law. This is the minimum wage law for the country, for the federal minimum wage law for this country. It's been in place for many, many years. The question is whether the Department of Labor can change its understanding of that law, change the scope of that law and who it applies to on a dime, and create a new standard for that law, which is so ambiguous that individual workers, ordinary people who have to be able to understand this law. I mean, your listeners, Uber drivers, my clients, freelance writers, I mean, they need to know whether are they putting their clients and customers at risk by working for them. In the case of my clients, and their customers are going to want to know that. But how can they, when you look at this rule, when you look at this 6-7 factor balancing test where no one factor is given any prominence, and the Department of Labor refuses to answer any questions about who's going to be covered or not? I think that creates a real problem for workers all across the economy. Regardless of the sort of appointments clause question, it's just outside of the department's authority.
Yeah, I've worked for a laser production company since the late 90s. I worked as a salary position for them for a couple years, and then I came back to Colorado, and now I just do all freelance stuff. I've worked for lighting companies, sound companies, pyrotechnic companies. I've done world tours. I don't see how my life wouldn't be just destroyed by this if it's enacted and pushed.
Right. I mean, the rule is going to go into effect. But the way the Department of Labor has crafted this rule, I think is very clever, because what it does is it chills relationships. You've probably talked on your show about the ABC test and AB5 quite a bit. But under the AB5 test, generally speaking, independent contractor relationships are really hard to create and to make legal. And so usually, accepting whatever the exceptions are to AB5, that if you're in California, you're going to be an employee. You're not going to be able to classify yourself as an independent contractor under California labor law. This law is a little different, right? What this law does is this law says you might be an independent contractor, you might not be. The Department of Labor, can't tell you, and I'm not going to tell you. But if you hire independent contractors as a business, you're taking your life into your hands because you don't know whether the people that you're working with are independent contractors. The only way you can try at your best to guess at it by looking at these 7 factors that we've given you and trying to read the tea leaves and guess, but you don't really know, and there's no way for you to know. The problem with that, one of the major problems with that, which we see, is it accrues to the Department of Labor, to bureaucrats in Washington, enormous authority to post hoc decide that certain workers should have been classified employees, were misclassified as independent contractors.
And almost like on a case-by-case basis.
On a case-by-case basis, absolutely. And in a way that would seem to ordinary people to be inconsistent. This creates this is what I would call a separation of powers problem. I mean, it puts the Department of Labor in the position of wielding a sword of Damocles, which it can drop on the heads of unsuspecting businesses that it doesn't like, and then cite to this rule, which is so vague that nobody can tell what the proper reading of it is or what the proper scope is, and say, well, we're just following our rule. And that's just not fair. That's not the rule of law as I understand it. And so to me, that's the major problem here.
So there's a couple of things here. I see John Lopez. John's in Chicago. He said the withdrawal of the 2021 Trump administration rule was struck down. Is this correct?
Yeah, I believe I said that. That's right. So the Department of Labor, the very first thing they did under the new administration is they withdrew the 2021 Trump rule in a short, essentially a short, quick withdrawal rule.
Right, Texas, but I think here he's saying that in an East Texas federal court, it was struck down.
I'm getting that. That's right. Then that withdrawal rule was itself challenged in federal court in Texas, and the Texas court struck it down. So we've been living with the so-called Trump rule or the 2021 rule here now for 3 years. I mean, it's been the law of the land. And the sort of the parade of horribles that the Department of Labor trots out in its rule to justify withdrawing this 2021 rule that hasn't come to pass. And I don't anticipate the Department of Labor says, well, we have to do this rule because otherwise there will be hordes of exploited independent contractors and we'll be powerless to stop it. And that's just not the case. The rule under the Trump rule gave businesses guidance. It told them what the rules are, but it didn't give them sort of unlimited carte blanche to classify workers as independent contractors and to not pay the minimum wage. That's not what it did. So I think that's been proven over the past 3 years.
Steve, they're trying again is what's happening. They tried once, the court stopped them. They're trying again. And now we're trying to stop them. Does that make sense?
Yeah, this is another attempt to do, but the difference between this and the withdrawal rule that was struck down is this is they're putting in place a new rule. The withdrawal rule in 2021 was struck down because the Department of Labor ostensibly didn't follow the procedures it was supposed to follow, right? When you withdraw a rule, you have to go through this process. It's called notice and comment. And it's a lengthy process. And you have to give a very reasoned explanation as to why you're changing your policy. So now here we are, 3 years down the road, the Department of Labor has now gone through this procedural process that the Texas court previously found fault with. They've issued their so-called reasoned explanation. But I think, as we explain in our lawsuit, the so-called reasoned explanation that they've adopted is still wholly inadequate.
Yeah. Karen Anderson here is asking, and Karen's a good friend of Kim and mine, but she's out in California. She has been absolutely devastated by AB5. And she says, how does a freelance editor of a monthly newsletter not fail at least 3 factors of the 6-factor test, or a weekly columnist?
Well, I mean, what's interesting about this rule is obviously without more facts, even with more facts, you can't ever say, looking at this rule, whether a particular situation is going to be classified as an employer or an independent contractor. You can run through those 6 factors. Yeah. You can say, oh, I'm going to fail 3 of those factors. But what the Department of Labor is going to say. And what they say in their rule is these factors can't be considered in isolation or even in combination. The only way to consider the factors is specific to a particular factual circumstance, considering the totality of the circumstances in an unspecified manner. We'll be able to try and guess at whether you're an independent contractor after having looked at all the facts. But that's no rule at all. That's the I know it when I see it test. The Department of Labor has simply adopted an I know it when I see it test. I know an independent contracting relationship when I see it. I have these 6 or 7 factors, but they're not binding on me. I can look at anything I want, and I don't have to tell you how I'm going to balance them. So, really what this is I'm going to look at a relationship and know it when I see it, if it's an employment relationship or not. And unfortunately, that doesn't give stakeholders, contractors, and customers who use contractors the guidance they need to be able to hire contractors without fear. And that's what
exactly
it's all about.
I mean, that's when we're talking about AB5. We've talked to Karen many times about how overnight they became toxic, all the workers. And so one question I would have for you is this I mean, neither are good at all, but is can you look at the 6-factor test as it could be worse? It could be the ABC test, because that B prong on the ABC test was just
right.
End all.
I think there's a way to think about it. And I said that a moment ago, right? If you're in California, generally speaking, it's very hard to be classified as an independent contractor, especially if you're doing something like Karen mentioned in her comment, writing magazine articles for a magazine, because you're going to fail the B prong. Here, the Department of Labor hasn't said that those people are employees. They've said, we don't know. They've said it's one of the factors and we'll consider it alongside all of the other factors. So you could say, well, this is better than ABC because there's a chance that person can keep working as an independent contractor. And in fact, I think that the result of the rule is, of course, going to be a chilling of independent contractor relationships. But I don't expect them to dry up completely overnight because the Department of Labor has left enough doubt that businesses can just decide to take the risk. And many of them, I think, will decide to take the risk. Some will not, and that's what's going to hurt businesses like my clients. But some will decide to take the chance and bet against a Department of Labor enforcement action, or bet that if one is brought, they can fight and win on the 6 or 7 factor test. The problem with that, as I mentioned a moment ago, is that the amount of uncertainty created is in and of itself a bad thing for businesses. And it's a bad thing for the rule of law, for the Department of Labor to accrue to itself the power to go after businesses it doesn't like, which is ultimately what they can do under this new rule. And businesses who don't know the rules, now they have to adopt a risk premium. And, is that better than just not being able to use independent contractors at all? Maybe you could say that it is, but I think for purposes of the rule of law and certainty and freedom of contracting, I think it is in some ways better to have a clear rule which tells individuals what is expected of them. Whereas here we have a rule which tells individuals that the Department of Labor is just going to be in a position to only tell what's expected of you after the fact.
Plus, won't they be in a position where to really, I mean, like you said, it'll take a while for people to even know this happened. It's kind of like AB5 happened, people didn't know. So won't they have to won't they actually have to get aggressive with some people to prove that this is serious?
Yeah, I think that I don't want to look too hard in my crystal ball. That's not my job, and that's not.
I understand.
I'll speculate a little bit that I think when this rule goes into effect, yes, the Department of Labor then has to bring enforcement actions to apply the rule and to show how they're going to use it in practice in some degree. And because the uncertainty of the rule is so great, I think that will lead to additional litigation. Now, it's worth noting as well that the Fair Labor Standards Act, of course, can be enforced by private lawsuits. So private individuals are likely to bring more lawsuits as a result of this rule. I think it's likely to kick off a wave of FLSA litigation against employers on behalf of disgruntled former independent contractors who feel like they should have been paid overtime. So I think that's, yeah, I think that is going to be a consequence of the rule. I think there will be a lengthy adjustment period because of the nature of the rule itself, the amount of uncertainty it creates. But I also feel like as long as this rule is in place, we're not going to settle in to, an equilibrium where people sort of understand what the rules are, because the rule is inherently uncertain. I think we're sort of heading into a world of profound uncertainty in terms of the scope of the Fair Labor Standards Act. Yes, I think unions will bring lawsuits. I think individuals will bring law. I mean, I think it's going to be a bonanza potentially because the standard has been loosened so much from what it was in 2021, and even to some degree what it was before 2021, when you just would have been able to look to the court. Here, the Department of Labor has said, don't look to the courts, look to our extremely vague, broad rule.
So I'm not sure how long we have you for. So Kim and I will be, I want to go with Kim through some of this stuff, but as of just question, I know again, it's a little speculation, but as of March 11th, what do you expect?
Well, our lawsuit, I don't know that our lawsuit will be able to get the rule set aside by that date. We'll just have to see. At this point, for our lawsuit, we filed our complaint. We filed it as soon as we could, within days of the rule coming down. But, the government has to respond, and there has to be a sort of litigation process. So the rule will probably go into effect on, in March as scheduled. So what's going to happen at that point? I mean, at that point, I think we head into a world of uncertainty. I think that the nature of the standard is so nebulous that independent contractors can probably keep doing business as long as their clients want to. But I think that the clients are going to start being chilled. I think the business is going to dry up a little bit. And I think as the lawsuits proliferate and the Department of Labor's enforcement actions proliferate under this new standard, I think we'll see a sort of gradual shrinking of the independent contractor sector. And that's the Department of Labor's goal. I mean, I think that they're very explicit about that, is they want to reduce the number of independent contractors and make more people into employees.
But if I'm correct, I mean, from many people I talked to, the number differentiates from 63, 65 million, 68 million. I've heard upward of 70 plus million independent contractors. That's 40% of the workforce.
Yeah.
And we know, I mean, I'd bet my farm on it.
Right.
I know that they can't even produce 10% of those jobs. They can't make 7 million jobs if they kill 70.
These jobs are not going away overnight. What the Department of Labor is seeking to do is to give itself this power, this sort of Damocles, that it can bring down the hammer against businesses and companies and business models that it doesn't like, and to do what it can to chill this industry from growing any further. But I think it's like you said, for all the reasons you explained, I think it's difficult to see the independent contractor in American life going away. I don't think that's going to happen. And I don't think that the Department of Labor necessarily intends for it to completely go away. Their rule is designed to create uncertainty. It's designed to chill, to create fear around the process of hiring an independent contractor. And it does that very effectively. But unlike AB5, as I've mentioned several times, the rule doesn't effectively prohibit people from being independent contractors. It just, for their customers, it creates legal risk. And
it just leaves a looming.
That's right. Hey,
we might pick you. Who knows?
Yeah, we might pick you. We might go after you. We might not. Your independent contractors, if they get disgruntled, they might come after you. You just have to. It creates this uncertainty. The Department of Labor is, like I said, they're hostile to independent contracting. The rule was supported here, as the Department of Labor's comments admit about the comments. The rule was supported here by quote unquote workers' advocacy groups and labor unions, essentially the same thing. These organizations are definitely hostile to the freelance business model and people being their own boss. And I think that's ultimately, this is one front on the battle that Kim is fighting. it's not the whole battle, right? The Department of Labor isn't able to prohibit independent contracting overnight. I don't think that's what's going to happen, but it's certainly a threat to businesses like Kim's, and that's why we're trying to stop it, because, as I said, it's illegal and unconstitutional.
And there's no exemptions, right, Wilson? Like a lot of what we talk about with AB 5
Right.
was that they ultimately exempted more than 100 professions, but that ain't happening here, right?
Well, of course not. The Fair Labor Standards Act, as I mentioned at the very beginning, applies to every employee and every worker in the country. If you're a worker, you have to, well, you don't have to worry, but the company that pays you has to worry about whether or not you're an employee or whether you're an independent contractor. And this is universal. So there are no exceptions in the Fair Labor Standards Act to this. Obviously, there are exempt employees from overtime and the like, but that's not what we're talking about. No one's really exempt from the minimum wage generally, with the exception of sort of narrow exemptions like piece rate and stuff. But
Well, I was going to also say like who's gonna challenge a lawyer?
well, right.
I mean,
There's no real question. There's no real question that I'm paid the minimum wage, I guess. But yeah, I mean, these enforcement actions that get brought, it's hard to see a pattern. And I think in the future, it's going to be even harder to sort of predict whether or not a particular job under the Department of Labor's test is covered by the Fair Labor Standards Act. And that's the intent.
You don't think that will precedents be set? Will it be used? Like if
Of
5
course,
writers get nailed, will they?
I think precedents will be set, but the way the Department of Labor's rule is structured is such that those precedents are inherently bespoke, right? I mean, the Department of Labor is very clear in their rule that everything is a totality of the circumstances test. And even if in a given case, a freelance writer was an independent contractor, for example, or another writer was classified as an employee, you have to look at the circumstances of that particular case, and we can weigh the factors differently in that particular case. So I agree. Yes, of course, precedents will be set. I mentioned this is going to create litigation. I think that's the inevitable result. But that's just not the way that this works. That's not the way it should work. The Fair Labor Standards Act can give people certainty. People should know when they're entering into a contract what the rules are of that contract. They shouldn't have to guess. They shouldn't have to engage in a detailed lawyerly and scholarly analysis of the precedents to try and figure out whether or not this relationship is an independent contracting relationship. They should just be able to, the person of ordinary intelligence should just be able to know, because it's important. We're talking about criminal penalties here. If you're an employer that works with somebody and you've misclassified them as an independent contractor, I mean, you could potentially be on the hook for major penalties. And so how can it be that the Department of Labor says, well, it may be that you could be on the hook for major penalties, but the only way to figure out whether the workers that you've hired are employees is to undertake this detailed 7-factor balancing test? That just can't be the rule, because people of ordinary intelligence can't apply that. So you're right, there will be precedents set, but is that really going to suffice to give workers the certainty that they need and give businesses the certainty they need to continue doing business? Again, my understanding of freedom of contract is that if Kim wants to be an independent contractor and the magazine that she works with wants to hire an independent contractor, they should be able to set up their relationship so that she's an independent contractor, whatever that
100%.
Right? But the Department of Labor won't tell them what that has to look like. That can't be lawful. That, in my view, that's unlawful. It runs contrary to the Fair Labor Standards Act. It runs contrary to the Constitution.
I think some of the underlining stuff you've been saying, even what I'm hearing, is this is really being thrown out there as a major scare tactic to the companies that potentially would hire Kim.
Yeah,
instead of the Kims who understand it and go, no, I know what I'm doing.
Right. No, I think that's exactly right. I mean, the Fair Labor Standards Act, Kim is not going to be penalized, right? I mean, she's generally, except through her business being destroyed, but
except through my
I was just going to say her livelihood will end, but okay.
that I spent 20 years building.
Right. That's a very important consequence. I'm not trying to understate it, but it's not the case that you're going to pay damages. The people who pay damages for quote unquote misclassifying you are your customers. And that's how this rule operates. It goes after the clients, the customers, and of independent contractors, and tells them, if you're going to hire an independent contractor, you're going to take your life into your hands. You're taking on a legal risk. And, we could sue you, or down the road, your former workers could sue you. So you better be careful. And to me, while some legal risk is of course inherent, businesses have to be able to know how to set up their relationships. And in my view, the Fair Labor Standards Act, which is this federal labor law that we're talking about here, it has sufficient clarity. It tells you that employees are one category of people, and businesses should be able to know who's an employee and who's not. Otherwise, what's the purpose of the law? It just might as well say the Department of Labor can bring an enforcement action against anybody they don't like.
Yeah. Yeah. And what's, if you have this great concept and this rule goes in place, and after March 11th, you want to start a new business, now you really got to weigh it.
Mm-hmm.
Wait a minute.
Yeah. If you're thinking about going into business as an independent contractor, I'm not going to discourage you, because I think that's great. You want to be your own boss. You should do that. But you need to understand that the rules like this one pose a threat to the continued stability of the freelance business model, because it goes after your potential customers. It says that, if your potential customers want to work with you, there's going to be a certain amount of legal risk associated with that. And that's not your fault, but it's something that you should be aware of as somebody trying to run your own business.
So Karen's saying the DOL claims it would only take an hour.
Well, look,
it's longer than the first Harry Potter book. Can you read that?
You can determine. It depends what you mean by determine if somebody's a worker, Karen, right? Ultimately, if they're, if you just want to take a guess, you can take a guess in 5 seconds. But in terms of actually determining whether someone's a worker, I completely disagree with that. The Department of Labor they're just saying how long it takes to read the rule, but they'll tell you can never determine in advance whether somebody's a worker or an independent contractor. You can't determine that without looking at the totality of the circumstances. And those circumstances could include things that you don't even know about. And the only way that we can actually determine whether you're an employee is really to ask a judge. A judge interpreting the law and interpreting this rule is the only person who can make that decision. That just can't be the way that this should work.
Wilson, one other question I've been getting, and I'm assuming Steve too, because of who his audience is. A lot of these are the folks who fought for Prop 22 out in California.
Mm-hmm.
And the question I keep seeing floating around online is, what, if any, effect does this have with regard to Prop 22? People seem a little confused about that.
Well, look, I'm not a California labor lawyer, so I don't want to get too much into the weeds about AB 5 and Prop 22 and the interaction between those and what's going on in the AB 5 and Prop 22 litigations. So without getting into that, I will say the Fair Labor Standards Act applies to every worker in the country. Okay, if you are a worker and if you're classified as an employee, that means your boss is an employer and they have to pay minimum wage and overtime. They have to be tracking your hours for purposes of knowing whether you're owed minimum wage and overtime, unless you're, an exempt employee, blah, 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 blah. That applies to you regardless of whether you're exempt from AB 5 or not. The laws don't talk to each other. They have nothing to do with each other. If you are an employee under the Fair Labor Standards Act, then you're covered by, your boss has to worry about the FLSA with respect to you. It has nothing to do with whether or not you would be exempt from AB 5 as a result of Prop 22.
So even if you fought for an exemption in California and you got an exemption from AB 5, whether through the exemption process or through Prop 22, that is irrelevant to what's happening here.
Right. It's just a completely different, it has nothing to do with this, right? Ultimately,
But the way you're saying it, they would go after Uber, Lyft, Instacart.
That's right. Yes.
DoorDash.
Well, labor would, yes. So the question is, the big question is going to be, and we don't know I don't know the answer to this. I don't work for Uber. I don't work for these gig companies. I have no idea. So, but the big question is going to be, is this rule going to chill or change the way that gig companies do business because they are afraid of the Department of Labor coming after them? Are they going to want to classify workers as employees, or are they just going to change the way that they interact with those workers so as their lawyers think that they can win a litigation on this new test, right? Because ultimately, like, the test creates so much uncertainty that if you're an attorney for Uber, you're going to look at it and you're going to say, okay, well, we can probably still continue working with drivers, but as independent contractors, but we need to be careful and we need to be very aware that there may be actions brought against us. And this new rule creates a lot of uncertainty. It's a trial lawyer's full employment act, I think somebody said in the comments earlier. I mean, honestly, like, I think that the impact is going to be a lot of litigation for big gig companies, but how is it ultimately going to play out? I mean, that's going to take years to figure out. And I just can't.
And it's not just Prop 22. We have the Washington State / Seattle pay up legislation for gig workers. We have the New York City new legislation, which says 50 cents a minute on active time, but they say they won't optimize you more than 65% of an hour. So you can expect to earn 18 an hour.
This is a multi-front war against independent contractors, right?
Yeah.
There's so many different laws that are trying, because as Kim, I'm sure, has talked about and will talk about, I mean, this is a major priority for certain advocacy groups, particularly labor unions, to crack down on this kind of freelance work. But, and the Department of Labor's rule is one front in that war, and we're challenging it because we think it creates this uncertainty without any sort of useful or lawful justification. But I don't mean to say that this rule alone is the only thing you need to worry about if you're trying to run your own business and be a freelance worker. I think there's all sorts of rules that are coming out there which are going to add legal risk to your business. This is just one of those rules. So you just should be aware. But yeah, I think that this rule is important, and because it covers everybody, because it covers all workers. Even if you might think that you're exempt for maybe 5, you're still going to be covered by this rule. But it won't, in terms of how it's going to play out. It's so hard to predict, and because it's in this changing system with all these state laws and all these lawsuits that are proceeding, not just ours, but of course I mentioned the AB5 lawsuit, and there's the Prop 22 lawsuit, and it's just too big a topic to go into detail now. Yeah. But ultimately it's
but at the end of the day, if they want it to, the federal overrides it.
Well, no. So the Fair Labor Standards Act,
This is why I brought a lawyer, Steve.
provides a floor for regulation. Okay. So what that means is that the states, generally speaking, can always go beyond whatever the FLSA provides. So if you are, let's say that your case gets litigated, right? You're a freelance, you're a driver in California or something. The Department of Labor goes after your employer and says that you should, or the company you work for, and says you should have been classified as an employee. If you win and it's determined under the FLSA that you are correctly classified as an independent contractor, that doesn't override the state's determination later, or let's say if Prop 22 got struck down, it wouldn't override the state's determination that you're an employee. It would just mean under these two different laws, which operate in parallel, that you would be an independent contractor for purposes of one law and an employee for purposes of the other. It's very confusing. It's very annoying.
It's very confusing.
It's why you get a 1099 then your employer lists you as an independent contractor on all of his forms, and it's just not relevant at all for purposes of the FLSA. It's just a different law. It's a very important law. It might be the most important law, but it only provides a floor. It doesn't override, and will almost never override whatever the state's regulation is, if that regulation is more restrictive. So
when like John here says the US DOL rule change through Fair Labor Standards Act will, left Lorena Gonzalez, who we all have a laugh about.
It provides a floor, right?
Okay.
So the Department of Labor can always, so for example, if this isn't an ABC test, as I've said several times, but AB5 has all these exemptions. We've talked about those a bunch. So for a particularly exempt profession, you're still covered by the FLSA. And if the standard under the FLSA goes up, as it has done under this rule, you're going to be covered by that standard, even if you're in an exemption to AB5. Think about it this way. Think about the minimum wage. Everybody understands, I think, the minimum wage in San Francisco is higher than a minimum wage in Biloxi, Mississippi, right? Absolutely. It's whatever, $15, $16 an hour, whatever it is in San Francisco. And it is the federal minimum wage, presumably. I don't actually know that. But let's say it is. The federal minimum wage is what the wage is in Mississippi. I think it's $7.25 or whatever.
$7.25.
Right? If the federal minimum wage goes up tomorrow to $10 an hour, the San Francisco minimum wage is still going to be $15, right? But now those workers who were previously, only covered by the $7.25 minimum wage will now have that new floor. So the Fair Labor Standards Act just provides a floor, and then states can go beyond that. But if a state has regulated in a way where previously they were regulating at the FLSA floor, and then the Department of Labor raises that floor by raising the minimum wage, or in this case, increasing the scope of the FLSA, then it will go beyond. It will seem like it's overriding the state, but it's not. It's just the floor is rising. As long as the floor rises, the states can't regulate. They can't ever exempt themselves from the FLSA, and the FLSA can't override. So, Trump, for example, couldn't have gotten rid of AB5. Even if he had wanted to. I don't know whether he did or not, but even if he had wanted to, he could not have gotten rid of AB5. So that's when I say they can't override the state. I know that's confusing, and I'm very sorry.
Well, no, if I heard it right though, so they're providing a floor. ABC test goes above that floor, but where some of the confusion and problems might lie is that there were a lot of carve outs in that ABC. So therefore, what value does that ABC have? We have to look into that.
Right. So if you were previously carved out of the ABC, you're still carved out of the ABC, but now the Department of Labor is raising the floor for everybody with their new test, which is more restrictive than their old test. So if you were carved out of AB5, the floor is going up. You're still, you're still covered by the FLSA. You're always going to be covered by the FLSA, or rather, all employees are covered by the FLSA. Whether you're an employee or not is the precise question at issue. So that's
what I've taken away from all of this is it's going to be a nightmare of confusion.
I think it already is a tangle and a nightmare. And the effort of the 2021 rule was to simplify this for a lot of workers and to say, like, here's a clear test. And by the way, usually if you are an employee, or, if you're an independent contractor under these various other statutes, you're going to be an independent contractor here too. So it's an effort to kind of simplify, but that simplification has been taken away. And yes, I think they've created a whole lot of additional confusion, and without justification in our view.
Well, did y'all catch that? Did y'all catch all that?
I remember, Wilson, when the 2021 rule was put in place. I remember Labor Secretary Scalia at the time. He wrote an op-ed, and he said, "We see what's happening in California. We're doing this to try and make sure that people are protected from the federal level, at least in some respects, whatever the federal level." That he was very cognizant in that op-ed of, we see what's going on in some of these states, and we're trying to do what we can to protect these independent contractors. That's how I remember it, if I'm remembering.
I think that's exactly right. I mean, the 2021 rule, of course, was in response to AB5 to some degree. that's not to say that it overrode AB5 in any way. It wasn't about overriding AB5. It was about, I think, setting an example about here's a clear test. You know, the Fair Labor Standards Act is sort of the model for the vast majority of states in the way they do their employment law, the way they do their minimum wage and overtime statutes. So they should model themselves off a clear test, which lets people understand what the rules are, rather than this mess of an AB5, which makes it impossible to be classified as an independent contractor and has all of these various exemptions, which just make no sense and are just clearly ad hoc in response to particular political pressures. So I think having a clear one-size-fits-all test is an excellent example for the Department of Labor to have set in 2021, which is why it's so disappointing that here we are in 2024 and they've gone to this nebulous black box, which gives nobody any useful guidance whatsoever.
So as a person who's a non-lawyer, am I correct to think the 2021 rule that was in place was written by people who thought AB5 was bad, which is the people I agree with, and the people doing this right now at the U.S. Department of Labor are the people who thought AB5 was great? And is that an accurate assessment of what's happening?
That's a fair approximation. It's worth noting that the Department of Labor in its rule is, of course, at pains to say, well, this is not AB5. This is, we're a totality of the circumstances test, right? So they're at pains to distinguish themselves from AB5 for, I'm sure, political reasons. But it's clear, if you look at the constituencies of the people who support the rule, that it is a lot of the same constituencies that support AB5 and support similar AB5 statutes. I said it at the beginning. I think the Department of Labor's ultimate goal is to chill independent contracting relationships, to reduce the spread and the growth of that sector, and to turn more people into employees where they can. It's not a dramatic rule, right? It's not a rule which is going to make, which is going to have huge overnight impacts, in my view. But it is a rule which is going to ultimately hurt a lot of people who are running their own business and who want to run their own business, because it's going to chill the growth of their business. It's going to chill their customers from working with them. It's going to change the way they have to do business in order to remain their own boss, and all of that, for what, right? And I don't think the Department of Labor has a good reason for what it's doing.
There. Well, I don't know how long we can keep you, or if we've kept you way over the time we can. Or
Well, I had this in my calendar for half an hour, so we have gone a little over time. But I always enjoy talking about this. So thank you for the chance to talk about the case.
Oh, thank you for coming on and shedding some. I know that you shed the wisdom you could, but at the same time, I'm still just feeling a lot of who knows. We'll see.
I wish I could get more.
You did. I think there's no more to give.
I encourage everyone to go to pacificlegal.org, read our complaint, try and understand, if you want to sort of understand what this case is about, read what we've written about the case, and hopefully, and what Kim is writing about it as well. And I think it's an important case. I think this is a really important rule. Just because I don't think it's going to have huge dramatic overnight effects doesn't mean I don't think it's hugely important. So please take a look at our lawsuit and our website. So thanks.
And that lawsuit, Steve, it's only 17 pages long. And I can tell you, he's a good writer. I know he's a lawyer, but he's a good writer. You can read it. It's in English. You can follow it when you read it. It's very understandable compared to that monstrosity that the Labor Department. It's fantastic. So read it. Take the minute to read the 17 pages.
Yeah, don't read the
guys.
rule.
I just posted it in the chat. So if you guys want to read it, it's right there.
So, well, thank you very much. I appreciate the time. Hey. So I'll log, and you can talk to Kim, and
we're grateful for you.
Wilson. Thank you for staying after, Wilson, and hanging out with us and talking us through some.
He's doing this pro bono for all of us, so we're very grateful for the Pacific Legal Foundation and Wilson in particular.
Thank you.
So you guys make sure to check this out. And I love their Twitter headline too. It says, "We sue the government."
What
I just saw it today. I love it. Thank you, Wilson. Appreciate you. Well, that was good.
That's why I brought a lawyer, right? It makes your head spin.
It does. I don't even know how. To me, it's like, I thought this 6-factor test was just going to be ABC test in a different language and different ways to catch people. But like I've seen you posting on social and stuff like that, is that, and like he just confirmed today, it is going to be like a case by case situation.
So I am, what am I allowed to say? So I'm in the unusual position of being a plaintiff in a lawsuit against the federal government, which means their lawyers are the United States Department of Justice, and I have to be careful what I say. So I'm not going to refer to the specific rule or the specific complaint, but what I will keep coming back to is things like the Mercatus research that came out this week. My dog agrees. Sorry about that. The Mercatus Center put out research this week where they looked at what actually happened from AB5. These are economists, like all that lawyer super nerd stuff that we love. Think economist super nerd stuff, right? The Mercatus folks put out this study where they actually looked at what we've all been saying. Hold on one second. We've all been saying it.
You might have to mute her mic here for just a minute, guys, but we talked about it beforehand. It's just going to be for a minute.
So people at home know I'm having a new boiler installed in the basement, and there's workmen coming in and out the front door while I'm trying to talk to you. Ginger is the guard dog. Sorry about that, everybody. The Mercatus Center, people in the chat are saying, be careful, the Justice Department will come after your dog. The Mercatus Center, what they found is what we've said all along, that what AB5 actually did was there was no evidence. They found no evidence that it increased traditional employment, either full-time or part-time. They also found that what AB5 actually did was reduce the level of overall employment in California by 4.4% and reduced the level of self-employment by 10%. So what we've been saying all along, this hurts people, doesn't help people. What they wrote about this U.S. Department of Labor rule, they said, they did like a comparison. Here's what we found about AB5 and here's what we think about USDOL. And what they wrote is that while the DOL rule is not as stringent as AB5, their rule cannot exempt any industries, occupations, or professions like AB5 did. Thus, the effect of the rule is expected to be more widespread.
So wait, therefore, then what I was trying to get to, maybe I didn't ask it correctly of them, was these precedents won't matter.
Again, I'm not a lawyer, and I can't answer that question.
But I mean,
way.
from what you just read,
I can tell you what the economists who wrote that study said was that here's what happened with AB5. They basically said it hurt people, didn't help people. And they're saying specifically that their analysis suggests the U.S. Department of Labor rule is going to have challenges in meeting its intended results. They expect the rule to be associated with a decrease in self-employment nationwide, just like AB5 did.
Mm-hmm.
Because like Wilson said, this is one front in the war, right? They started with AB5 in California. They tried to spread it to New Jersey. We stopped them in New Jersey. They tried to spread it federally through the PRO Act in Congress. We stopped them in Congress. Now here we are at the U.S. Department of Labor. So it's all the same people. People are policy, and it's all the same people who want fewer independent contractors out there. So the ins and outs of how they achieve that goal, as Wilson just explained to everybody, there's a lot of legal mumbo jumbo in there, but their intent remains the same. And I think that's the most important thing for regular folks like us with normal sized brains to try to remember.
Oh, 100%. I saw some comments in here about that I wanted to go back to that were John's. So he was talking about Kevin Kiley. I didn't know about this. Is this?
Yeah. So Kevin Kiley used to be a state level lawmaker in California, and he fought really, really hard against AB5. He was then elected to Congress. So he's a new member of Congress. And one of the first things he did when he got in was try to protect the country from that AB5 situation spreading. He chaired a hearing on Capitol Hill last year where I was one of the witnesses. Karen Anderson, who you mentioned earlier in the program, was one of the witnesses. He's trying to bring attention to the issue. He's done a number of things. And he laid out all of them in a tweet that I can show you. And the thing on your screen is one of the things that he did. What he said that he is intending to do is a couple of things. One of the things is he's introducing legislation under the Congressional Review Act to try and nullify this U.S. Labor Department rule. He says this is a fast-track procedure for overriding as an executive agency. I know they're working on that now. I know they're asking people to call their lawmakers and ask them to sign on as co-sponsors for this Congressional Review Act to stop the USDOL rule. So everybody listening can do that. Tell people to join with Kevin Kiley in that. He says the second thing he's done is secured language in the labor appropriations bill. So that's money, that's funding, right, for labor in the federal government. He has gotten language into that bill, not a law yet, but bill that would provide, it says that no funds may be spent to enforce the rule, which would render it a dead letter. Now that's a bill, right? Politicians got to argue about that. It's going to go back and forth. We're going to see. But right now, he's got that language in there saying that no funds may be spent to enforce this particular rule. So they're going to try to keep that in. Third, he has joined with Representative Elise Stefanik to author the Modern Worker Empowerment Act, which creates a clear legal standard to protect independent workers. That's a bill that I've seen a number of lawmakers promoting online, and that I think if we see big trouble here on the horizon, is going to potentially become part of the upcoming political campaign, because it's going to become a campaign issue at that point. Fourth, he says, Kevin Kiley says, he's introduced the Department of Labor Succession Act, which has already passed through committee. He's trying to stop Julie Su, who is the acting Secretary of Labor, and he calls her the architect of AB 5. He's trying to stop her from clinging to power, despite the Senate rejecting her nomination as U.S. Labor Secretary. Fifth,
so I need to ask that. Is she acting again? Because I didn't know you could do that.
President Biden just renominated her, is my understanding.
Right. But I didn't know you could do that. I thought that's what the 220 days were about. I think if you can't make it happen in that, find somebody else.
I think Kevin Kiley is saying he's trying to make that very point that you're making, and he's trying to do it in Congress. And he says, fifth, he expects there will be court challenges. Here we are, based both on the dubious legality of Julie Su remaining in office and the overly broad nature of the USDOL rule itself. So you just heard one of the lawyers talking about that. And then he says, finally, as chairman of the House Subcommittee on Workforce Protections, he will continue to conduct rigorous oversight of the Department of Labor and do everything possible to protect workers against this administration's overreaching policies. And I heard him say on a different podcast yesterday that he's getting ready to do more hearings and try to get this into the news a little bit more. Is what happens when you have hearings.
Wow.
So the guy is really punching above his weight. We all should be applauding Representative Kevin Kiley on this issue. I don't even think I know where he stands on most other issues. I just know that he's been a champion of this, both at the state level in California and now at the federal level. He has fought tirelessly to try and protect us from this nonsense.
Yep. I'm putting in the file. I only did it for YouTube, you guys, and I just realized that. But here it goes to all the platforms. That is the lawsuit that was filed by Kim and two other women from New Jersey and one from Georgia.
Yeah, so it's the women who are the leaders of Fight for Freelancers USA. Karen Warren lives down in Georgia, so it's called Warren versus I think U.S. Department of Labor. Karen is the lead plaintiff because that's where she lives. And then up here in New Jersey, you have the three of us who started Fight for Freelancers when it was just a state thing in New Jersey. That's me, Jen Singer, and Debbie Abrams-Kaplan.
So will you file something there as well, or does it not need be?
No, it's filed in Georgia, and then Wilson does his thing.
Right. I was wondering if then, because I've seen the same logo, the Fight for Freelancers New York. I mean, these are popping up, and I know that your group is growing. Will they do it in all their states, or is there no need?
No, there's no. So the reason you're seeing different state things. What happened after we created Fight for Freelancers? We did that in 2019 because the state of New Jersey, which is where I live, they tried to pass a copycat of AB5. We created a group called Fight for Freelancers New Jersey to stop that, and we did, and we won. And for one day, we were super happy, and then the next morning, we read a story that said, oh, the same language, the same regulatory language is now in Congress at the PRO Act. And we said, oh my God. And then there was a bill in New York to try to copy AB5. And then there was a lawmaker in Illinois talking about trying to copy AB5. And suddenly our Facebook group, Fight for Freelancers New Jersey, was talking about all these things that had nothing to do with New Jersey. So what we did was we made separate Facebook groups for each of the states to talk about state-specific issues. And then on the Fight for Freelancers USA Facebook page, we try to keep it on the federal level. And a lot of the state people are in the federal group too, trying to understand how it all interacts, obviously. But, you know, like in Minnesota right now, we have Fight for Freelancers Minnesota going. They've started the ball rolling. They've created a misclassification task force where they're talking about introducing the ABC test. And it's a lot of union sympathizers on that task force. And there's one independent contractor we're aware of on that whole task force. She's a member of our group and she's doing her best. But we all know it's a fait accompli, right? That it's a sham. The misclassification task force exists to make a report that says, hey, we need AB5 in Minnesota. So that is something they talk about on the Minnesota Fight for Freelancers page, while things like the USDOL rule or the PRO Act are what we're talking about on the USA Fight for Freelancers page.
Sure.
As Wilson said, it's a multi-prong war.
Right. But I mean, at the same time, you don't oppose people making, or do you, making a post about New York, because it might be very relative to, well, wait a minute.
Oh yeah, when people learn something in one state versus another, people talk to, the whole point of social media is to be social, right?
Right, but I mean, when you kind of separating the groups, but then you have the federal level one on that one, I would assume people could still bring in, hey, this just happened.
Of course, absolutely, yes.
Yeah.
We do our best not to clog it up where you're getting 45 notifications an hour because it can get a little unruly. We try to keep it manageable. None of us are paid to do any of this. It is all just regular people trying to keep their careers and keep their small businesses. So,
as a mod of two Facebook groups, one of them is specific to DoorDash. The person who has it has two groups. One is 100,000, one is 80,000. And as a mod on that, she puts out some really good advice. She always says, make sure you read all the comments before you comment, please.
It would be helpful. We got such a surge of new members.
That's what I mean. Like, make sure your question wasn't already.
I think our membership went up something like 10% in a week when the USDOL announced this thing. And people are terrible. It's the same exact thing that happened in the States, where in California, people, oh my gosh, what are we going to do? And everybody who didn't live in California said, kind of sucks to be in California. I don't know what they're doing out there. Nobody thought it would happen to them. Then it came to New Jersey and people like me said, oh my gosh, what are we going to do? And the rest of the country said, I don't live in New Jersey. What? Now it just happened to the whole country. And we're getting a lot of, oh my gosh, what am I going to do, from Tennessee, from wherever, all over the country. And it's folks trying to play a lot of catch up really fast. And I think that it's why we need podcasts like this, so people can try to understand what we've all been talking about for a few years. Because if you don't live in one of the targeted states, this is all brand new. This is all brand new to everybody. And they're learning all this stuff for the first time. They don't know how hard people have been fighting against this. They don't know how hard the lawmakers and regulators have been trying to squash the opposition, and just how brutal it has been trying to do this as regular people. And they're about to learn for the first time when they call their lawmakers and the lawmakers go against them. I think it's going to be a pretty rude awakening.
Oh, I do too. I think it's crazy as it is. Like, I don't know. I feel like, that this is where it has to get a little political, because there's no way this guy's holding his position. So, I mean, no matter what he does, doesn't it just get thrown away later?
Hard to say. I don't have a crystal ball about who's going to win the White House in November. But what I will say is this about that.
I mean, how easy and why didn't he do this 3 years ago?
Well, they tried as
I know,
well.
but I mean, this doesn't seem that legal either. I'm going to be honest.
Well, we're suing them. That's why we're
Right.
suing.
And even what I was talking about though, in the Kevin Kiley thing about just like, if you were trying to do this as the PRO Act and all these other things, it didn't work. So now you're just going to say, well, we're just going to do it anyway. We're sorry that you're too stupid to understand it.
This is why they're getting sued. So in terms of the politics, here's what I can say about that. Back in 2021, March of 2021, the founder and editor of the Daily Kos website, which is one of the most progressive websites on the planet, they raise money for the super far left progressive candidates. The founder and editor of that website asked me to please write a story about what we were seeing in California and New Jersey, because what we were seeing in California and New Jersey was massive grassroots resistance coming from Democrats, coming from liberals. It's a lot of women. It's a lot of people in creative industries who get hit by this thing. It affects people in more than 600 professions. But you anger writers, singers, actors, musicians. These are not people who are afraid to get in front of a microphone, right? So a lot of the public outcry was coming from people who knew how to raise a ruckus, and a lot of them were Democrats. And so the founder of the Daily Kos asked me to write this story, and I wrote it. And I said, look, you can go back and read it. It's still on their website. I've got it on my Twitter feed at the Kim Kavin on Twitter. I wrote that if the Democrats don't stop attacking their own base with this policy, you're going to have people walking into voting booths saying, it's my career or yours. Do you really want that to happen? Do you really want to be saying to people, do you want to be giving the other side, the Republicans, this giant issues baseball bat to swing at your heads in an election year? And that's exactly what I wrote was going to happen 3 years ago. And that's exactly what's happening right now. We're seeing this week the backlash against this rule going into effect. It's not just happening in right-wing media. I was reading it the other day in USA Today. People saying this is absolutely idiotic. What is the Biden administration thinking? USA Today, Steve. So
yeah, I know, right? It's now in the publications that I would have 2 weeks ago said they'll never write that.
They'll never write that. And now they're writing it. And so I think we've hit I'm so sorry to say, another milestone in this unbelievable saga that none of us ever wanted to be a part of. And here we are. They want to keep coming at us, opening new battlefronts in the war. Here we go. This is it. We're here again. Let's go.
Yeah, I just know for a fact if they start enforcing this, we know it from California, fail, no jobs. I mean, again, on Twitter, a couple people have actually, and they're friends of yours too, have actually alluded to, no, I know of 100 jobs that were created here. I'm like going, yeah, but there were millions killed.
Well, this is
when I'm saying, were there any created? I mean, 100.
This
and
is
then
what
are
the
there
Mercatus
tens of
study,
thousands created somewhere we don't know about?
Yeah, this is what the economists at Mercatus Center just published, and they were just super duper clear that they found no evidence that AB5 increased traditional employment. They found that it consistently reduced self-employment, and that the decrease was larger in occupations who have more self-employed people. So it's the same thing we've been saying all along: this is freelance busting. That's all this is. This is people who don't want freelancers to exist, trying to come up with ways to get rid of us. That's what they're doing.
I wonder if Karen has the stats on how many business licenses in California were granted last year compared to years prior to, or some year, where she could do the comparison of, look, post AB5, pre AB5, because I would think there's a lot less created.
I can't answer that. I don't know the California stats on that. All I really know is this. What I've been looking at this week is the stats in that Mercatus Center study, and it just could not be clearer what their findings were. And the stories that have come out trying to tear it down, I have found interesting as well. Where one of the folks who's always been against us just came out and said, "Well, I just don't see how any of that could be true." That's it. That's the argument. I just don't believe it. We're all going, That's the equivalent of no with your fingers in your ears. You know.
I mean, here's Lisa's comment, and hi, Lisa Rothstein. I'm glad you're with us on Twitter.
So I am aware of one writer who was turned into a W-2. I heard Karen Anderson say somewhere that she is of course aware of a handful of people who were turned into W-2, but it's the same thing that the Mercatus Center just said. You know, the offset doesn't matter. You're still seeing a decrease in employment. The Mercatus Center pointed out that even W-2 people lost work because of this, because some companies that rely on the smaller businesses that rely on a mix of independent contractors and employees, what the Mercatus folks, what they found this week was, well, if you got to get rid of the independent contractors, now the business can't do everything it used to do. Now the business uses clients and some of those businesses go out of business. Now the employees lose their jobs too. That was what the Mercatus Center people are saying is part of this.
So is this basically just, to me, this is just the PRO Act on a case by case basis.
I think there's I think the reasonable way to say it is the people who thought the PRO Act was a good idea are now in leadership at the Department of Labor. That is accurate. And it is the Department of Labor that is doing this. People are policy. The goal remains the same. They're trying to come at it from a different way, which is what Wilson said as well.
Yeah, and John Lopez here mentions a good point, because Karen has that list of 608. I actually made for you YouTubers, there's a video up about the 608. It's about 2 minutes long. And if you look at number 608, if you look at number 608, go look at what it is, you guys. YouTube creators.
Isn't that funny? Irony, right? Actually, Representative Kiley read, I don't know if it was that whole list, but he read a bunch of it on the floor of the U.S. House of Representatives. He was rattling them off like chocolate, vanilla, strawberry, banana, you know, on and on. But he was saying professions the whole time and trying to get lawmakers to understand. Look at what we're talking about here.
Yeah, I mean, because that list is that. I mean, the film industry alone, I have a friend, Tremaine Hayhoe, owns Hayhoe Studios. I mean, I was showing him and he's like, dude, that's every single thing that I work with. That's 100 things that I work with.
Well, it's 100% of my income as a freelance writer.
But he's in California too.
And
he's like, wait, he's one of those people who's still, it was about 6 months ago, I finally told him this was a thing. He didn't even know.
I think that what we're going to start to see now is more people learning, especially like Wilson said, what did he call it? The Trial Lawyers Full Employment Act. That was a funny line. As you start to see the big lawsuits come in and fines being levied, obviously people are going to notice. There's going to be headlines.
Okay. There's Karen saying that PRO Act was National Labor Relations Act, and but to me, it's still kind of just the same thing anyway.
Well, I can explain.
It's like if you walk into that room, you have no idea what's going to happen to you. If you get called upon, you're going to walk in there and you're going to go, what? I work for myself. I always have for 20 years. Get off my back.
Here's the way
we'll determine that.
Here's the way to think about that. When President Biden was still candidate Biden and he was running for president, on his campaign website, he wrote that with AB 5, he thought California had led the way. And it was his intention to work with Congress to make that same policy from California the policy for all federal labor, employment, and tax law. The PRO Act was specific to labor law, right? Step 1 in labor, employment, and tax law. The PRO Act did not get through Congress. We helped to stop that. So now he's coming at it a different way. But again, it's all the same people. People are policy, and the goal remains the same.
Yeah. We have a very, very serious comment here from
For the people listening at home, she wrote barf. That's what we're looking at on the screen.
So what is John? So John he's in Chicago. He's always, I don't know, you know John, right?
Yeah.
Yeah, okay. So he's
from online, really.
Yeah, from Twitter, probably. but candidate Biden also wanted to completely repeal the Taft-Hartley Act.
So what the Taft-Hartley Act does is that's the reason independent contractors can't be unionized. It protects us from that. We are small business owners. The folks who have been trying to change the definition of us into employees, they don't like the Taft-Hartley Act. They've been trying to get rid of it since it became law. And they want everybody to be able to be unionized. So it all falls into that same bucket of the goal remains the same. We can talk about 47, like Wilson said, you can talk about 8,000 different kinds of laws and things. The goal remains the same: freelance busting.
Yeah. And then I know Derek's here in my market. He does gig work. It's, on a case by case basis, central control, picking winners and losers.
I hope that folks found it helpful. I certainly sleep slightly better at night knowing that we got smart lawyers with us. The Pacific Legal Foundation has an outstanding record of winning at the United States Supreme Court. We are lucky to have them as our pro bono attorneys handling this. I actually heard Representative Kiley on a podcast earlier this week say he was aware that we had filed our lawsuit, and if he could have chosen a law firm, this is the perfect one to take this case. So we are hopeful that we will succeed, and we just all have to wait now and see what happens next.
Karen's saying he read them all. Yeah, he read them all. I mean, that's a long list to go through too. Your mouth gets dry. I've started that one. I get to about 1:30 or something, and I'm like,
Kevin Kiley on the House floor. Yeah, you know what? What we can do is Representative Kevin Kiley has fought tirelessly for us. What we can do for him right now, he needs help getting co-sponsors to use the Congressional Review Act to try and stop this U.S. Labor Department rule from going into effect. So if you appreciate what Kevin Kiley has been doing for you, you can return the favor by making a phone call to your congressman. Go online, type in "find my congressman." It'll let you punch in your zip code. It'll take you right to their website with their phone number and their email. Tell them you want them to sign on as a co-sponsor with Kevin Kiley to use the Congressional Review Act to stop the U.S. Department of Labor rule. That is what we can all do today, right now, to try and help Kevin Kiley.
And as I've said a couple times before, guys, we finally have this dialed. That we had it as we were collecting like on a on one of the free websites collecting signatures, but we moved it over to a real server. Now, if you go here, the site is very clean. Driver singular rights.org, driverrights.org. If you just click, if you look through the website, if you agree with it all, just say get involved. You put in your email, your zip code, your name, and it finds the people that should be written for you. And it actually writes a letter that you can go in and add to, write yourself, clear it out, or just send it as it is. So it takes literally, if you don't want to write it and you just want to do the pre-written one that we did, it takes 2 minutes, maybe. That's it. So we made it easy. That's all platform gig worker based, by the way. So that's not for the traditional independent. You guys could, of course, please add your name to it. But so because we have 70,000 signatures on that now.
That's fantastic. And I know we have members of Fight for Freelancers have been talking in our Facebook group. They're calling their lawmakers. They're getting people to sign on. People are fired up. So come and help. We're not asking much. It doesn't cost you money. It takes maybe 90 seconds max. That's all we're asking you to do. Turn off TikTok for 10 seconds and do this. Yeah. So John Lopez is asking about, there was a press conference today. I have not seen it, but I've seen the lawmakers who were there on Twitter today. Representative Kiley led the podcast, but he also had state lawmakers there from California. And he was talking about this bill to use the Congressional Review Act in Congress to stop the USDOL rule. They also apparently announced a bill to try and repeal AB5 outright in California. I didn't catch the names of those state level lawmakers, but I retweeted them. They're on my Twitter feed if folks want to go and thank them for what they are trying to do.
I'm surprised. Kevin's pretty good about getting videos out pretty quick, whether it be YouTube or Twitter or other things. Something that big, I would think well, if it's not out yet, it'll be out soon, I would imagine.
Well, I had to come here, so I didn't have a chance to
right.
look it up. I do see Tony Hope asking in the comments, do we have a list of Congress people who have already signed on? Tony, what I do have in the Fight for Freelancers USA Facebook group, if you want to join us there, is a list of co-sponsors that they're still trying to get, at least on the Republican side, where it's probably going to be a little bit easier. So if you want to join us at Fight for Freelancers USA over on Facebook, you can see that list and see if anybody from your district is on that list, and whether you making a phone call would be especially important. I have not memorized the list, but
in that banner, I have scrolling at the bottom, I have it as Fight for Freelancers. Should I add USA?
Yeah, fightforfreelancers.com goes to our New Jersey website, but the homepage says if you're looking for the USA group, click here. So you can.
Oh, no, I meant for Facebook.
Facebook, if you go to Facebook and type in Fight for Freelancers USA, it'll come up. It'll pull up all the Fight for Freelancers groups.
Right. When I typed in Fight for Freelancers, it showed them all, but it showed the main group at the top.
Yeah, the USA group is the one with the yellow logo. Looks like looks like a little ray of sunshine.
So there we go. So okay, that should be right then. There we go. Yes. So that's Kim's Twitter handle, the Kim Kavin, and then Fight for Freelancers USA will pull up all the Fight for Freelancers groups. So you could do the USA, and then if you live in, I saw New York. I think I saw Minnesota one.
Yep.
I don't know how many states have already started these, but
got a bunch.
You might see one for your state as well.
And the state ones, they get active and then they go down, right? If something's happening in the state, you get more activity. And like the New Jersey group, we've been a little quiet since that bill passed. We've been focused more on the federal place, but like the Illinois group, the Minnesota group, they're a little more active right now because there's some things going on in those states.
So Karen Anderson is saying that she saw it today. It's not on YouTube as of yet, though.
The press conference.
Right. So it must have been on something, though, to watch public TV. I don't know.
I didn't catch it. But I'm glad she was watching. She can she's a good reporter of information.
So here's Assembly Member James Gallagher leading the repeal. So
that's a state California Assembly Member James Gallagher. Everybody go thank State Assembly Member James Gallagher in California for trying to repeal AB 5.
Yeah. And realize gig workers with the repeal of AB 5, bye-bye Prop 22. I mean, I hate to put it so bluntly, but without that law, there's no reason that the companies would have any.
Can you imagine if after all this, they just repeal? Like, this has been 5 years of 5 years. Are we at 5 years? Has it really been that? Yeah, it has.
Well,
it's constant aggravation at this point since 2018, 2019.
It's 4 years.
AB 5 was introduced in 2018. It was passed in 2019. It went in effect January 1st, 2020. So, but the fight started before it went into effect. So this has been people fighting for their careers for 5 years now. Can you imagine if after all of that, they're like, never mind. I mean, the lunacy of that, right?
So does anyone think Gavin Newsom would sign a repeal? I don't live in California. I don't like Gavin Newsom at all on any level. I think I'll watch my language, but I mean, the pandemic was a perfect example. He would say, don't do this. And he'd do it the next day, literally. Like, don't turn on your air conditioning. He's sitting there in a t-shirt in an air conditioned room. We can have all electric vehicles, but turn your air conditioners off. We're going to flood the grid.
I don't know when he's up for re-election, but I would imagine, here's what I would imagine is that if this becomes a campaign issue in 2020, November of this year, with the campaign going on right now, I can't imagine it doesn't also become a campaign issue in California at a higher level than it's ever been.
Wait, so what Lisa says here, now that Lorena is gone, it could happen. Not sure how in bed with unions he is besides teachers union. So Lisa, are you saying that the connection between Newsom and Gonzalez, with her now union shell and not in the role she was, that maybe he would step away from it? I mean, he's got to be getting some hate mail by now. I doubt many people write him that bang up job with that AB 5.
He seems to have higher aspirations to me than remaining in charge of California, but what do I know?
Right. Well, I mean, didn't he just get shot down like right out of the gate this time? Like, I think he's starting to realize his higher aspirations might not I don't know what I mean, sure, he's probably going to make more money after office. Most politicians do, but I don't know what he's going to do politically.
Nor do I.
Because
Yeah.
I don't know who's going to be a part of that.
We all will live and learn together.
I mean, the other states, I don't even know if, I mean, do blue states like him? I don't even know who likes him.
I don't know.
I mean, I know the red states hate him, but like, I don't even know if the blue states like him because he's such a liar.
I know who just dropped out of the race. DeSantis didn't like him, right? Didn't they debate on one of the channels?
Yeah, so I don't know. So it's so Karen had said the Prop 22 is a business and professions code.
Karen knows all. Karen's like Wilson almost about this. She's not a lawyer, but she knows all the lingo inside and out.
Not a single one, not a single incumbent Democrat in California has come out against AB 5 since it passed.
So here's where we actually have a little bit of an advantage at the federal level. We have seen a handful, and I stress on one hand, I can count them, but we have seen some Democrats come out and say we need to protect independent contractors. That's why the PRO Act didn't pass. It wasn't just Republicans who were against it. We had Senator Mark Warner in Virginia, who's a Democrat, Senator Mark Kelly in Arizona, who's a Democrat, and Senator Kirsten Sinema of Arizona, who at the time was a Democrat. She's now switched over to be an independent. They all refused to sign on and pass the PRO Act. And what Senators Warner and Kelly actually made public statements saying that it was because they wanted to make sure the independent contractor language was correct. They had seen, Senator Warner said he had seen what happened in California. We wanted to make sure that we fixed it. And so, and I can also tell you from our meetings, the Fight for Freelancers folks, we take meetings with lawmakers whenever we can get in. Behind closed doors, there absolutely are Democrats who tell us they know this is wrong, but then they come out and vote for it because they're afraid to lose the campaign contributions from the folks who want it. So it's not that there is no support for independent contractors among Democrats. It's that we need to get a lot louder as voters and let them know that we want them to exercise good judgment in public about this and stop it. They need to stop these attacks on the right to choose self-employment.
I'm confused by this. John, are you asking if California governors are term limited? I thought for sure they were. I mean, you can just be there forever and be awful. It's like, I like this comment too. I wanted to hit it before we got too far away because obviously it's Gavin Newsom.
The ladies of the View love Gavin. See, I got to tell you, I don't watch The View.
Nobody watches The View.
I'm writing stories.
No, he is. Okay. So no. And then Karen, yes, he is term limited. Okay. Well, I mean, that's really good to hear because I would hate that. 2028 is what Karen says. That's still a long time.
Well, I'm glad we at least had a chance to let folks know that there is some stuff they can be doing right now to try.
100%.
Yeah. And I appreciate you offering us the platform to do that, Steve. You've
of course.
been a real champion of this cause, and we're grateful for you too.
Yeah, of course. I mean, I'm in it on two different fronts. I'm in it on my one profession, but I also have really been watching all this gig legislation and what a joke it is. Because I don't see this. I think for all you gig workers who are living in Seattle and right now liking it or like Prop 22 or the New York City 30 cents a minute thing for active time, I think all these are meant to just backfire on you. The companies are so good at getting deceiving about these and then finding these ways to just not, yeah, cool, I make this much a minute, but you'll never be optimized. You'll work 3 hours on the app, you'll get 1 hour of work. So at that point, what is it? Because of the oversaturation stuff. But Kim, thank you for joining us. I want to thank Wilson too, and Pacific Legal Foundation. You can find Kim at all these things that have been scrolling on the bottom, you guys, and in the show notes. Fight for Freelancers. You can find her on Twitter, and I think pacificlegal.org. Let me just throw that back up there one more time.
I'll let him know next time I talk to him how grateful everybody is for their pro bono representation. I know I sure am.
Yeah, I mean, like Kim was saying too, these people, like when, whoever mentioned, who's leading, spearheading something or this or that, thank these people. Like if you're on Twitter, thank them.
We're real people. I'm standing here without heat or hot water because they're replacing my boiler. And we're still fighting. There's no heat and hot water for the rest of the night, but we're still fighting.
But it's warm there now.
I don't know about warm.
Didn't it warm up today? No, I thought you guys were like in
New
12,
Jersey. There's
15 degrees.
There's snow on the ground outside my house right now. So
I know. I thought you guys moved up to the low 50s or something today. But
no,
anyway.
I'm gonna go build a fire in the fireplace and see what else we can do to throw a wrench in the monkey works of this stupidity.
All right. Well, guys, thank you for joining. Thank you for watching on the replay. Thank you for listening on the podcast. And I want to thank Kim again. I want to thank Wilson. And you guys be safe, earn smart, and be good to each other out there.
Bye, everybody.
She was just a baby.